So I've got 6 o'clock right on the dot. Feel free to take it away whenever you're ready.
Okay, thank you. Good evening. We'll go on the record now, and this is the time and the place. It's about 6 o'clock, and it's time and the place for case number 247-23-00210-PA and 240-23-0000211-ZC. This is a hearing for those files. My name is Greg Frank, and I'm a hearings officer that have been assigned to this matter. Before we turn to the particulars of the hearing, I would like to turn things over to Mr. Ripper, the staff planner for Deschutes County, and he's going to explain how the electronic process works. Mr. Ripper?
Thank you. And good evening. For the record, my name is Jacob Ripper, and I am a principal planner with the Deschutes County Planning Division. The item before the hearings officer is a comprehensive plan amendment to change the designation of the subject property from agricultural to rural residential exception area, and a corresponding zone change to rezone the properties from exclusive farm use to multiple use agricultural. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. And the county has established some time limits for testimony as follows. The applicant will be allotted 30 minutes, 10 minutes for any public agencies that are attending, 3 minutes for anyone from the public, and then the applicant is afforded a 10-minute rebuttal period. But the hearings officer can modify these time limits or eliminate them completely. The testimony portion of the hearing will be as follows. The applicant will present first, followed by any agencies. Next, people in support will testify, then those in opposition will testify, followed by anyone who is neutral on the application. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony. And then finally, staff can make any closing comments or answer any questions that the hearings officer has. So this is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet. I will use this list to call up participants for the testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When hearings officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you are in person, please submit your written testimony to me after your oral testimony. If you are participating remotely, you can submit your written testimony by email to me at jacob.ripper@deschutes.org. Hearings officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. At this point, staff would like to ask, are there any objections to the format of the hearing? If you are attending remotely and have an objection, please use the raise hand function. Okay, and seeing none, I will turn it back over to hearings officer Frank. Thank you. Oh, Greg, we can't hear you.
Thank you.
Yep.
Thank you, Mr. Ripper, for a number of things. As he described, we are following the normal hearing procedures of the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience as we make sure that we can get through each and every one of the steps that the planner just outlined. The application is being considered through the quasi-judicial process. I will consider only the factual evidence that's in the record. I will then apply those facts to any relevant provisions of the county comprehensive plan and relevant land use regulations. The standards and the applicable criteria relevant to this hearing were identified in the public notice announcing this hearing. They are also set forth in the staff report. The public notice and staff report are both posted on the county website, and they are also available directly from the staff if you make such a request. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criteria must apply and do so with specificity so that other participants may respond and so that I can actually address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to that issue in my decision precludes an action for damages in the circuit court. As just noted, I serve as a county hearings officer and have been assigned to do so in this matter. In that role, it is my role to be a neutral decision maker. Thus, while I may have had contact with the county to serve in this role, I'm obligated to remain impartial, and I do not represent the county's interests or interests of any other participant. To that end, I will state for the record that I do not have any personal, social, business relationships with the applicant, and I am not aware of any connections that I may have with other participants in this proceeding that would prevent me from remaining impartial. I have, in fact, communicated with staff, but only to the extent of scheduling this hearing and transferring information to me that's already in the public record. And I have not had any discussions whatsoever with staff regarding the substance of this application. I can tell you that I do not have any have had no ex parte contacts to disclose in this case. So at this point in time, what I'd like to do is, with Mr. Ripper's assistance, I would ask that if anyone wishes to challenge my ability to make an impartial decision or thinks I'm not the proper hearings officer to make the decision in this case, I would ask that if you're remotely, raise your hand, and if you're in person, to make sure Mr. Ripper is aware. Mr. Ripper, do we have anybody objecting to my participation as the hearings officer in this hearing?
We have no objections in the room or online.
Thank you, sir. It is my obligation to preside over this hearing in an efficient manner, and to do that, it would be helpful that I have some at least idea of how many of you are here and how many people are here, and both in person and online. So, Mr. Ripper, can you help me with that?
Sure. We have one person in person. It's the applicant's attorney. And then we have two people online.
Two people online. And have they identified whether they're pro, opposed, neutral? Do we know that at this point? It's not important. I'm just asking.
Yeah, I believe they are pro because I believe it's the applicant and their son.
Okay. All right. I just, so those of you who are participating in this hearing want to know, as a panelist, I have the ability to reach up here and look at participants. But the problem is I indicated already, I don't know any of you folks, and so I don't have any predisposition on this case any way, shape, or form. But I also was just curious as to kind of how much controversy we're going to have. But that whatever it turns out to be will be. Finally, if anyone desires a hearing to continue. All right, so let's assume that we got all through the oral testimony today. Normally, what I would do is close the hearing. And close the hearing means that nobody gets to submit any additional information into the record, at least new evidence or general argument. So on occasion, people want to be able to keep the record open so as to be able to submit additional evidence or argument. So if anyone is in that position, I just want to make sure you're aware that when you testify, if you do me a great favor and let me know that you wish the record to remain open. You don't have to do the opposite and tell me that you want it closed, because it will close automatically unless somebody makes such a request. If someone does make a request to keep the record open, then at the end of the hearing, I will talk about the logistics. Actually, Mr. Ripper will talk a lot about the logistics, and I will add my comments here or there. So if you want the record open, let me know. If you don't have to say anything. At this point in time, I'm going to turn it back to Mr. Ripper to deliver the staff report. Following that, the applicant should be prepared to make any presentation that he or she wishes to make.
Thank you. Yeah, so I just have a short presentation really to go over some of the details of the subject property and what the proposal is. The property's located about 1.5 miles north of Ben's urban growth boundary. It fronts on Hunnell Road along its western boundary, and it's about 40 acres in size. It sits roughly equidistant between Highway 20 to the west and Highway 97 to the east. This is a map of the zoning in the area. It might be a little bit hard to see, but the subject property is right in the middle with a red box around it. The yellow shading is multiple use agricultural zoning, MUA 10. And then the orange and kind of tannish brown further to the right of the image, both of those are exclusive farm use zoning. So those are both EFU zones. Again, the request tonight is an amendment to the county's comprehensive plan to change the designation of the subject property from agricultural to rural residential exception area, along with a corresponding zone change from exclusive farm use to multiple use agricultural. The applicant is not asking for a Goal 3 exception in this case because they have argued that the subject property does not constitute agricultural land. So what is agricultural land? It's defined both in the Oregon Administrative Rules and the Deschutes County Code. But essentially it is land that is predominantly composed of class 1 through 6 soils. So the applicant has submitted a soil survey that provides greater detail than available from NRCS maps. And that determined that just over 65% of the property is composed of class 7 and 8 soils. So in other words, it is not predominantly class 1 through 6. There are other factors in the OAR about identifying and defining agricultural land. For example, considering availability of irrigation or using the property in conjunction with another farm. But really the main factor are these soil classifications. All the record materials are on the website on the screen right now. I know that's a very long URL. You can also get to the hearing website where all those materials are by going to the community development website. That's deschutes.org/CD, clicking on Community Engagement Center. And that's where we have all of our applications that are currently working through the hearings process posted, along with corresponding record materials. So the review process for a plan amendment zone change is slightly different than a typical quasi-judicial proceeding. It requires an initial public hearing with a hearings officer, which is what we're doing tonight. The hearings officer will consider everything in the record, testimony given tonight, any materials submitted tonight, including an open record period if that's requested. and then issue a recommendation to the Board of County Commissioners. We'll hold a second mandatory public hearing in front of the Board of County Commissioners. They will deliberate after that hearing and then either direct staff, if they would like to approve the proposal, direct staff to adopt the hearings officer's findings as their decision or modify those findings as they see fit. So once that decision is written up and finalized, the commission will sign an ordinance, and that's the tool that actually amends the county's comprehensive plan and the county zoning map. So I promised it would be quick. That's all I wanted to share, but I am available for questions from the hearings officer if you have any.
I'm going to hold I only have one, and it's going to be dependent on whether I ask. It's dependent on where I hear the testimony goes. It's based, I will just let you know in advance, on the staff report referral to the state of Oregon, or land use for Land Watch versus Deschutes County case that was referenced. But I prefer not to talk about it quite yet, although the applicant certainly may wish to do so. With that caveat, then I'm going to ask if the applicant or applicant's representative wishes to testify, and if so, come forward or raise your hand and let us know who you are, first and last name. I will tell you that I'm not a great speller. So please spell both first and last name and then give us your address, please.
Good evening. My name is Liz, L-I-Z, Dixon, D-I-C-K-S-O-N. I am an attorney with the law firm of Dixon Hatfield, LLP here in Bend. I represent Mike and Kathy Groves as the trustees of the family trust that owns the subject property. My address is 400 Southwest Bluff Drive, Suite 240, Bend, 97702.
Thank you. Go ahead.
I believe that the people who we have remote are Chad Groves, the son of Mike and Kathy Groves, and Darren Kelleher, the consultant for the Groves. Is that correct?
We have a Darren, we have a Chad, and a C. Groves.
That might be someone else. Okay. That said, while I appreciate the 40 minutes, the staff report has been very complete and detailed. And my burden of proof was extensive. I'm not going to repeat what's in those documents. What I'm going to do instead is extend a few of the arguments that I think are important to help you make your decision. The key here is that this piece of property is one of those that's part of what I call the Great Overlook of 1979, where Deschutes County went through and in trying to figure out what would be farm and what would be forest and what would be exception, things that were already developed into fairly small acreages or with houses were put into the exception lands. Things that had trees on them were forest and the rest was farm. This was one of those parcels. This 40-acre parcel, to the best that we can determine, has never been farmed. It's not even cleared. As a result, it has not been developed, even though we've been sitting with the system now for some 50 years, and we're now to the place where we need land for housing and for other purposes besides being parked for farm when it's not being used for that purpose. In this case, this land has been analyzed, and it's Exhibit 4 that lays it out very well. And it's 65.4% Class 7 and 8 soils, which on this side of the Cascades means it's deserving of a non-resource zoning designation. So 26.2 acres is unusable, which meets the standard of non-agricultural land. The rezoning standard essentially focuses on public interest. We meet all of them. It conforms with the comp plan statement and goals. It matches the purpose and intent of the NUA zone. It is okay with public health and services and facilities and the impacts on surrounding land uses, which are small hobby farm residential on 3 sides, Deschutes County's 80 acres on the east side, also never used for any purpose that we can find. And the fourth thing that we look for in the rezoning standards is that the zoning is the result of a change in circumstances or mistake, which I think we have identified both here. The circumstances in the area have changed considerably. There's housing on three sides. Hunnell Road has been improved this year, or is being improved, I think. And it was a mess historically. It had boulders in it, and it wasn't straight, and it wasn't all the way paved. That's all been cleaned up. And this is all part of an ongoing push to make the area north of Bend developable, because most of it is exception land. As we all know, Bend is continuing to grow, and this is an area that's been identified as likely for growth in the future. The next issue that I'm going to deal with is, because the staff report basically went through and said, meets it. I think where I want to focus my time is on the definition of agricultural lands, what is and what isn't. Historically, Weatherell is the case that carries the day. It's a 2007 case at 342 Oregon 666. It's an Oregon Supreme Court case. And Weatherell v. Douglas is the case that sets out a very clear standard for when you determine when property is agricultural or not, based on profitability and how that profitability is measured. That's the case that is essentially in play as a result of the land use decision that was made by Deschutes County last year, in the matter of either Eden properties or 710 acres, depending on where you look at it in terms of the timeline. But it's the same case. It's 710 acres of land up in the Terrebonne area, almost to Lower Bridge. And in that case, Deschutes County approved the rezone from EFU to, I believe it was RR10. And it was appealed by just about everybody that I can think of who would show up and appeal it. Central Oregon Land Watch appealed it. Thousand Friends of Oregon appealed it. The Keystone Ranch and the Red Side Ranch, the ranches near the subject property, appealed it. And 3 agencies got together and went after it as well, with the Department of Justice's help. DLCD, OWRD, and ODF&W, if I remember correctly. So it was a real lightning rod for the issues that are pertinent here. If the tech guy will turn to put my exhibits in, I'd like to submit 4 additional exhibits to the record. I believe they will be 11, 12, 13, and 14, if my numbering is correct. And those exhibits will show you the following. Exhibit 11 is the tax map that shows the 710 acre properties. Are you having any luck pulling that up? Yes, good. Okay, a little hard to see. No, that's the wrong tax map. That's the Groves tax map. I'm looking for the 710 Eden tax map. That's it.
Ms. Dixon, I don't mean to interrupt, I guess I do, but I just want you to be aware that I have sitting to my left side a copy of that LUBA decision, and on page 5 there at least is one map, and I believe it's 710 properties.
It's the exact same map. That's where I pulled it. So to put it into the record, here it is. This will be
That's
exhibit
cool.
11. Okay.
Great.
This shows the 710 acres that is the subject of what's currently an appeal to the land use to the Court of Appeals, and depending on how that comes out, possibly a remand to Deschutes County. The second one that I want to show is an aerial photo of Eden 710. And if you look at the two together, you can see where the subject property is and all those crop circles. The outlined portion is just tax lot 500 on the tax map. The actual property goes all the way down to Buckhorn, but is bordered to the north and the west Not completely in crop circles, but pretty much. There's a mining site up there as well. That's what's going on in Eden 710. To give you a sense of what the area is. It's over 4 miles away from the nearest UGB. It has farming and ranching as near we can determine on all sides of it. And it's been the source of great contention. The second two exhibits I want to show you, which will be 13 and 14, are the Groves tax map, which shows tax lot 800 down at the southern end. It's a square, and it borders, Hunnell Road is on its west. So you can see the difference. It has the Deschutes County property to the east of it, tax lot 700. To the north of it, it has a Sun Cloud Estate subdivision. To the west of it, it has a series of parcels, which I think are 5s. No, they're 10s. I'll submit this to the record. So this is 11, that's 12, this is 13. And the last thing is an aerial photo of what the Groves property looks like, so you can see the difference. The Groves property aerial photo in the red box is property that has never been cleared. You can see the trees. There's a little bit of irrigation up to the north, but as you can see, it's not very good. The Swally Irrigation Canal runs slightly to the north and east of the red box. But no one has ever bothered to serve these properties down where the Groves property is, because the assumption is, I think they thought it wouldn't work. Now, I'll give these to Jacob so he has them.
Thank you. Thank you, ma'am.
Thank you.
The reason I go to that purpose is because I want to be able to distinguish between the Eden 710 situation and the situation that we have before us. First of all, it's not settled law. The Court of Appeals has not yet made a determination. It's not in direct contradiction with Weatherall, but I think some would say that Weatherall will decide the day. Because the question that's in play is, when you're looking at whether something's agricultural land or not, the question becomes, what do you need to prove that it is or isn't profitable? What disqualifies it as agricultural land? What lengths do you have to go to in order to make the determination that, well, it could be agricultural land? Now, I have heard arguments made, they didn't carry the day, that, well, we could put greenhouses up over an entire parcel of property and turn it into a giant marijuana farm, and that would be ag. That, to my knowledge, that argument has not yet carried the day. That level of involvement in determining what would it take to determine something's agricultural or not. No one's made it go that far, to my knowledge. But in looking at the remand that Luba laid out, I think it's important to look at what those issues were and show how they don't apply here. The first issue, and Jacob does a good job of identifying these in his staff report, and I'll go in the same order he did. On page 36 to 37, the Luba remand said that Deschutes County didn't consider profit in money in conjunction with other property. The argument there being that you should be able to look to the properties around the subject property and make a determination whether, if farmed cooperatively, for example, maybe you could put barns on this property, or maybe you could store things on this property, or put silos on this property. If you could use this property for something other than the good use of the soil itself, Luba is suggesting that is a greater length that local decision makers should go to in determining whether it can be used for ag. Weatherall, frankly, didn't say that. They said the profitability was much narrower and much simpler than that. Weatherall is Oregon Supreme Court, and it is good law. But in this case, if you were going to look at it, going back to those exhibits I just submitted into the record, if you look at what's around the 710 properties, there's ranching and there's farming all around it. And there were two ranches, both of whom are on the appeal, Keystone Ranch and Redside Ranch, who said they would like to be able to use the property. They had purposes for it. So they had actual evidence in the record to that effect. There is no one here making those arguments. There is no farmland that's being used around the subject property. The Deschutes County property to the east is fallow. It's never been used. Neither is any of the rest of it based on what we've seen. And if you look at the aerial photograph, you'll see very little of the land is even cleared. The second argument that was raised is at pages 37 to 42, where they talk about alternate sources of feed or dryland grazing. What Luba was saying there is that a local decision maker has a responsibility to look at not just how many AUM units are possible on a given piece of property, or how many cattle could it sustain for a period of time, but what if we were to bring alfalfa in from another location? What if we were to supplement in other ways? In this case, the dryland grazing issue was addressed in the soils report. And he said that the dryland grazing wouldn't work here, that it would only sustain maybe 1 or 2 head on 40 acres, which in cattle people's terms is not doable. But the profit idea based on the factors in OAR 660-033-0020-1AB, they think should be looked at more carefully in the 710 acres case. That's not the case here. We don't have ranching on one side and farming on the other here. We don't have a situation where the soil has ever been used for any purpose other than just unused land. So I would argue that in this case, the argument that Luba raised is not applicable, even if it does at some point be determined to be good law. The third argument that was made on remand was that in pages 42 to 46, that it could be used for equipment and storage. Again, in this case, I suppose you could build 40 acres worth of barns and silos, but there's no land around it to be served by it. So it doesn't serve a purpose. The assumption, I think, when they suggested equipment and storage use was that there was farming or ranching nearby that would benefit from that purpose. Barns for alfalfa, silos for grain, whatever other purposes they were thinking of. The assumption is it's in support of farm use that's nearby. Here we have none. On page 46 to 49, they suggested farm use in conjunction with nearby adjacent land should be considered. Again, we don't have any. So that argument would not be applicable here. And finally, on pages 69 to 74, Luba suggested that Deschutes County needs to consider surrounding resource lands and not just non-resource lands in terms of the effect on water, wastewater, and traffic. In this case, the only resource land in the near vicinity is the Deschutes County fallow land to the east, the 80 acres that's there, which is being used for nothing. So the idea that this use might take away from water, wastewater, or traffic issues, it doesn't apply. In fact, the application next phase, where we subdivide the property into 410s, includes provisions for a road which would go right down the middle, running from west to east, that would allow the Deschutes County property to have access for the first time, which it currently doesn't. It's currently landlocked. So in a way, what we're looking at here would actually improve the accessibility or traffic of a resource land that is adjacent to the subject property. So for these reasons, I would say that the Eden Acres 710 properties decision, such as it is, making its way up to the Court of Appeals and through the Court of Appeals process, it is, first of all, it's not settled law, but secondly, I don't think it's applicable here. And I think I've provided reasoning for why that's the case. We have no neighbors who are concerned about this application, to my knowledge. I checked the record recently, there was nothing. No comments of any kind that were negative. I would argue that in this case, it is completely distinguishable from Eden Acres 710 properties. And other than that, I think the arguments that were brought up by staff in the report and by me in the burden of proof show that this application satisfies the necessary criteria and is appropriate for approval. And that concludes my remarks at this time.
Thank you, Ms. Dixon. I'm going to have at least comments or questions for you later, just to alleviate any concerns you have. I'm thinking about this process both from just a purely legal apply a rule to a kind of case like we're talking about here. And it seems to me that the 710 decision is modified how I've made decisions within the last month or so. So it theoretically, in my opinion, it creates new rules the way I have to, or at least how I make decisions. So I'm looking at it from twofold. Number one is sort of, I understand this is not settled law yet, so don't take anything serious. But I'm looking at it from that and also from the purely factual evidentiary basis. And as a compliment to you, and I don't give very many compliments as a hearings officer, you've been in hearings of mine before. I never hardly compliment anybody. I guess I'm a curmudgeon. But with that said, I will tell you that your presentation regarding the differentiation, both from the exhibits and your narrative that you just gave about how this is different than 710, seems to me has provided me, even if I agreed with the 710 decision, it gives me an ability to make a decision that still remains consistent with that decision as well. So that's a compliment. Don't get used to it. It won't happen often. But the factual distinction was really well done. I'm not sure quite how to address the appeal, the 710 appeal, the Luba decision. So with that, then, is there anyone else wishing to testify on behalf of the applicant? Mr. Ripper, or anybody else wishing to testify on behalf of the applicant? Did they raise their hand?
Colleague, we don't have anyone else online, and there's no one else in the room.
that makes it easier. I gotta admit.
I don't have any raised hands, so that's it.
All right. So with that, then, the question I was going to ask, so Ms. Dixon, you can stick around. Just from an editorial perspective, and once again, I don't give very many compliments, and I don't editorialize a whole lot in these things, but I can't recall in being a hearings officer and doing land use for a long time, but being a hearings officer for over 20 years, I've ever read a case or a Luba decision that almost forced me to remove the rest of my hair because it was the biggest challenge of reading and not getting angry and going, what are they talking about? Because I'm a great admirer of Luba's analysis in most cases. They've been upset with me on occasion, and certainly remanded cases of mine. But I'm a great respecter of their legal abilities and their approach to cases. This one I have to editorialize and say I just didn't get. There were parts of this case I simply didn't get, and despite my editorial, I still have to follow the rules and the laws. But the question I have for you is, I think I can make this decision since there's no one testified in opposition. There's nobody going to have standing, at least before, with respect to my particular recommendation. I think I can make my recommendation based purely on a factual basis. And I can try to make that compliant as possible with the 710 decision. I'm not sure it's actually appropriate for me to analyze it and come up with a conclusion that makes me feel good right now. That basically says this is kind of a silly decision. in part. There's parts of it I agree with, but when we're talking about the other lands and the profitability and the overemphasizing and profitability, it just doesn't make very much sense to me. So do you have any problems that I simply use your factual analysis and factual evidence, distinguish the 710 case to this particular case, and determine that in fact it does not require a goal 3 exception? It's agriculture. Okay. All right, Mr. Ripper, I'm asking you the same question because the county obviously has a stake in this.
No objection from me.
Okay. So what I'm going to do then is I'm going to take, Mr. Ripper has already said that he wants additional findings completed by the hearings officer with respect to this particular issue anyway, or at least he suggested that. And so I think that's what I will do in the decision. Since there's no opposition, I can tell you up front that I'm going to recommend approval. And I will run through the analysis that basically Ms. Dixon has provided to buttress what I believe are already acceptable findings. I made a decision or a recommendation, 3 or 4 weeks ago, where Planner Stewart was involved. And I didn't think about any of these things that 710 brought up, quite honestly. So I will do my best to address the 710 decision, but it's going to be purely on a factual basis, if that's okay.
Thank you. Yeah, that's fine.
All right, Ms. Dixon, anything further?
No.
All right. No one's requested the hearing to remain open or the record remain open, so that means I'm going to close the hearing at this point in time. Mr. Ripper, you do me a great favor. I would like to work on this for the balance of this week, since the record hasn't been kept open. If you can get that particular those exhibits that were submitted on behalf of the applicant, the 4 they were referred to as 11, 12, 13, and 14. If you could get those to me sometime tomorrow, that would be greatly appreciated.
I can certainly get them to you tomorrow. That's no problem.
Okay, with that, then we'll close the hearing. Thank you all so much for participating. Anything else before I close? Hearing's closed. Okay, good night. Thank you.
Thanks.